Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Hello and welcome to SCOTUScast. I'm your host, Justin Drewer, on behalf of the Faculty Division of the Federalist Society. We're here today to discuss Merrill v. Milligan, which was argued before the court on October 4th. It's my honor to introduce our guests today, David Warrington and Professor Michael Domino. David Warrington is a partner at the Dillon Law Group, where he leads the firm's political law practice. Professor Domino is a professor of law at Widener University Commonwealth Law School, where he teaches courses related to constitutional law, election law, federal courts, statutory interpretation, and criminal law. And with that, I'll hand things over to our guests.
The case of Merrill v. Milligan was argued at 10 o'clock. It was a longer argument because there were a number of parties and a longer time was granted for the arguments. But the case came about because after the 2020 census, Alabama created a redistricting plan for 7 of its seats in the U.S. House of Representatives. This plan included one majority-minority district. And after the plan was announced, several minority group organizations challenged the plan and argued that there should have been more than just one majority-minority district. The challengers alleged that the map effectively minimized the number of districts in which Black voters could elect their chosen candidates, and therefore it violated Section 2 of the Voting Rights Act, which bans racial discrimination in voting policies. A three-judge panel of the district court agreed with the challengers that the map likely violated Section 2 of the VRA and granted a preliminary injunction. The petitioners in the case petitioned for a stay in the case. There was a hotly debated dissents and opinions regarding that, but today was argument on the merits focused on whether or not Alabama's redistricting plan violated Section 2. So at issue in the case was whether under traditional districting principles, you could have come up with a more than one majority district in the Alabama redistricting. The plan that was put forth by Alabama only had one. And in the course of the trial, or the course of developing the case, the evidence below, the parties used a number of experts and used a lot of computer simulations to come up with ways to show that there were multiple ways to doing this. And the arguments here between the parties were really focused on a couple of nuances in the Voting Rights Act, particularly whether the Voting Rights Act required the consideration of race, or whether it required treating race as sort of an uber factor in determining compliance with the Voting Rights Act. The respondents, who were the challengers in the case below, argued that what you needed to show was that what Alabama needed to show was that there was no other possible way to draw any districts without a majority-minority composition. That sort of turned things on its head, according to what Alabama argued, and the justices you could see where they were drawing their lines. The first Justice Jackson, who is her second day on the court, really took an active role in questioning Alabama on what basis they had to challenge to support their single majority minority district. And basically, she went back to the history of the 14th and 15th Amendment and said that, I think the way she phrased it, the 14th and 15th Amendment were adopted in a race-conscious way. And that meant that under the Voting Rights Act and under the test that's used, the precondition test, the Jingles test, that you can consider race and you have to consider race. That's really kind of a different. It's a different and new argument. I think the cases that came after Jingles really focused on traditional districting principles such as compactness, regularity of the lines, communities of interest, things like that. And if race is a component of that, it cannot predominate. And if it predominates, then it's a violation of the Voting Rights Act. And what Justice Jackson seemed to be saying is that you have to give race sort of a superior consideration in the analysis, because historically, the 14th and 15th Amendments were adopted in a race-based way to give a constitutional grounding for later laws such as the Civil Rights Act of 1866. Now, I think the counter argument to that, and I'm not sure it came out very clear, but the counter argument was that, while the 14th and 15th Amendments prohibit the deprivation of rights based on race, it is not a command or a license to use race. It kind of flips the understanding of the 14th and 15th Amendment on its head, which is what they would do with the current test in Jingles if you took her viewpoints. Justice Sotomayor sort of followed that line of arguing to some degree, and that's the main challenge to the argument of the petitioners here. We didn't get a lot of questions. I don't think we got any questions from Justice Gorsuch. Justice Alito really carried the torch in challenging the approach that Justice Jackson and Justice Sotomayor, and to some extent Justice Kagan, were advocating with their arguments. I think the Solicitor General of Alabama did a good job finally coming back around and wrapping things up and making the point that it cannot be under the present test that Jingles requires consideration of race as a predominant factor. In fact, that's inconsistent with the case law that's at issue. There was a little bit of back and forth on that. And I think the ultimate question that is posed to the court, and this is where Justice Roberts, I think, has the middle ground here, is whether whether they get rid of the Jingles test, which I don't think is even possible that they would do. But they specifically asked the Solicitor General of Alabama, do you want to get rid of Jingles or do you want to modify it? And I think the argument was, when he finally got around to that and clarifying that it's a modification, not really a modification, but a clarification of what Jingles is asking for, the test that Jingles requires. And I think that's going to be where the decision comes out, even though you can't read everything into oral argument. I think you may get enough votes to clarify Jingles rather than do either what Justice Jackson wants, which is import race as more of a presupposition or precondition to any analysis, or certainly because Alabama's not asking for either rewriting or modifying Jingles.
Thanks, David. I think it might be helpful for me to provide a little bit of background on the existing law, especially for the benefit of people who aren't involved in voting rights cases on a daily basis, may not remember much of the basic doctrine. This case involves a conflict between two different lines of jurisprudence that the court has developed over the last 35 years or so. One of them is on Section 2 of the Voting Rights Act, and the other one is directly under the Equal Protection Clause. The Equal Protection Clause racial gerrymandering cases, starting with Shaw versus Reno, establish that it's unconstitutional for a state to draw district lines with, as David said, the predominant consideration of race. Now, the Supreme Court has never said, in fact, it has expressly disclaimed this idea. It has never said that it's unconstitutional to consider race in drawing district lines. Instead, the court has said that race can't predominate. So race can't be the overwhelming factor that is considered. You can consider race as long as you consider it in a context with a bunch of other kinds of factors. It's similar to the affirmative action doctrine that the court will reconsider, where you can consider race in college admissions and things, but not by itself, only in conjunction with other factors as well. So that's the racial gerrymandering rule. You cannot have race predominate in the drawing of district lines. Section 2 of the Voting Rights Act, on the other hand, seems to require, or at least as Alabama is arguing that this isn't the proper way to interpret Section 2, but at least as it has been, to my knowledge, understood to this point, Section 2 has required the district line drawers to consider race to ensure that that racial minorities have an equal opportunity to participate in the political process and to elect representatives of their choice. So what Section 2 of the Voting Rights Act requires that minorities have that equal opportunity whenever a state is involved in standards, practices, or procedures with respect to voting, including the drawing of district lines. So what the Jingles test that David referred to tries to give some practical guidance to explain when you're going to have a viable claim under Section 2 and when you're not. And what Jingles says, apparently Jingles or Gingles, depending on who you ask, Justice Alito used the second formulation, and some of the other justices used Jingles. But that test, Thornburg versus Jingles, says that for a plaintiff to make out a successful Section 2 claim, the plaintiff must demonstrate that the minority group is sufficiently large and geographically compact to constitute a majority in a single member district, and there must be racially polarized voting. That is, that minority group must vote in a sufficiently unified way so that they have a candidate of choice, and the majority, what the court refers to as the white majority, must vote sufficiently as a bloc to enable it usually to defeat the candidate of choice of the minority. And if all three of those conditions are satisfied, then the court will ask, considering the totality of the circumstances, does the racial group have this equal opportunity compared to other members of the electorate to participate in the political process and to elect candidates of choice? And the Supreme Court has said, even though minority groups don't have a right under the Voting Rights Act to elect a proportionate number of its members into legislative office, when we consider the totality of the circumstances, we will make a judgment as to, about whether the number of districts controlled by the minority group is roughly proportionate to that minority group's share of the population. And so in Alabama, where blacks constitute roughly 27% of the electorate, the claim in this case, and the finding of the district court below, was that 2 seats out of 7 would yield a roughly proportionate number of legislative seats compared to the share of the population that blacks have in Alabama, whereas the current 1 seat out of 7 would not be a roughly proportionate share. So the district court, in finding that blacks were sufficiently large and geographically compact to constitute a majority in a single member district, and that there was racially polarized voting, and that the second majority-minority district would be necessary to bring blacks up to a roughly proportionate share of legislative seats, congressional seats, found there to be a Section 2 violation. Now, the essential conflict between those two different lines is what's brought out by Alabama's submission here. Alabama says, in order to say that blacks are sufficiently large and geographically compact to constitute a majority in a single-member district, you have to draw districts with the predominant consideration of race. That if you consider other kinds of factors in a more substantial way, particularly if you want to retain the core of existing districts, if you want to tinker with district lines as little as possible, you're not going to be able to draw a district that has a plan that has two majority-minority districts. The only way you do that is by prioritizing race. But that effort conflicts with the racial gerrymandering cases that says what you can't do under the 14th Amendment is draw district lines with a predominant consideration of race. So it's that kind of conflict that's involved in the case. And I think that that's what Chief Justice Roberts was referring to in his dissent from the stay application back in the summer, where he said, the district court appears to have applied Jingles correctly as it exists now, but the doctrine as it is causing substantial problems, in part because we have this kind of collision course that Section 2 seems to require the consideration of race, even as in a case like this, where race really has to be important to overwhelm other kinds of considerations to get a second district that just barely is a majority-minority district. And yet, we have this doctrine on the other side that says, whatever you do, whatever you consider, don't make race the predominant factor. So, David, back to you with any more thoughts you have about that.
Yeah, Mike, that's an excellent point that you raised at the end, because I think if you look at if you go back and you look at the dissents from the stay and also the stay and the arguments that were made at that point, I think you can see where the court's kind of lining up, and Roberts is the pivotal vote, as I think he often is. But one of the last questions, and I think it was on rebuttal when they clarified what Alabama was looking for. Were they looking for a rewrite of Jingles, or were they looking for a clarification? And the Solicitor General said a clarification. And that goes directly to what Justice Roberts had said was the problem that he thought, even though he dissented from the stay, he recognized that some of the interpretation of Jingles, I'm going to say Gingles, at the district court levels has been confusing. And even Justice Kavanaugh had said that before, that the case law and some of the stuff is confusing. And I think the two goalposts right now are for a clarification of that. But I think that Justice Jackson and Justice Sotomayor, and carrying along Justice Kagan, if they had their way, they would inject race into the predominant place in the analysis.
But is there? That's the question that I had that centered around all of this is on this question of whether Alabama was arguing for a clarification or a rewrite of this. Isn't it just the case that step one of Jingles almost of necessity makes race predominate in this inquiry? If you're asking whether can we draw a district that includes a majority of members of racial minority groups, it's hard to imagine an interpretation of the Section 2 language that does what Alabama is asking here, unless you were to say, use the constitutional avoidance canon or something like that and say we have to adopt a kind of counterintuitive reading of the text just to avoid the possibility of considering race in an unconstitutional manner.
I think isn't that what Justice O'Connor sort of warned of? That this would all collapse into a race predominant analysis. So I take your point. I that's why it was a little difficult. That issue was bubbling, right at the surface, and they didn't get around to really pressing on it until I think it was in the rebuttal. And I don't know if they really got an answer. They got an answer that Alabama was looking for clarification. I'm not sure they got a clear answer of what that clarification is.
Well, that's I wondered. What I was wondering was whether that was just a kind of litigation strategy, that if you ask for clarification, you're more likely to get it than
well,
then I want to overrule this case that's 35 years old. But when I was looking at the potential implications of this decision, that's what it would seem to me, that if Alabama wins, this is likely to be a major case, whereas if the challengers win, it may not be quite so major, because the only way for Alabama to win this case is for the prevailing understanding of jingles to undergo a fairly significant shift, whatever label you put on it.
Yeah, and I remember seeing some commentary in the early stages of this case where people were arguing for jettisoning jingles, but that seemed to be a bridge too far. And I think maybe that's why it was settled on let's try to get some clarification. But I agree. I think if the lower court decision stands, it's kind of a big nothing. But if Alabama wins, then we're looking at a fairly, probably a regime that you could have forecast in the law, but certainly something different than what exists now.
Now, one other thing that I'll ask you about that seemed to be bothering the liberal justices was, if we adopt Alabama's view, call it the clarification, do we, in essence, undermine Congress's 1982 amendment? That is, that the point of the 1982 amendment was to get rid of the intent test that was and remains in the 15th Amendment, and that was in Section 2 of the Voting Rights Act until the court decided Mobile versus Bolden, and then Congress amended Section 2 in 1982 and replaced this intent test with a results test. And the liberal justices were saying that what Alabama is trying to do with its interpretation of the new Section 2 is to revive the meaning of the pre-1982 Voting Rights Act. Do you think that that's an appropriate criticism, or is there some kind of middle ground there?
I think that's a criticism that leaves out an important sort of distinction. Taking it from Alabama's position or argument would be that all they have to do is prove that their map was reasonable under the conditions of the other things that you analyze, whether geographically compact, communities of interest, not bizarre lines and things like that, the prior districts, the pre-existing districts, and all of those things. And if the argument is from the liberal justices that you have to jump to, rather than by doing that, you're getting to an intent standard or an intent analysis, which is not, which is what was rejected in the 1982 amendments. I think that flips it on its head, because the argument from the liberal justices really is you've got to consider race, more than you're considering it. And that's what the challengers here did. If you look at the record below, there's a lot of testimony about, and one of the experts actually said, the main input that they had in their statistical analysis to produce these maps was race was the main consideration. And that's, that's what the liberal justices are arguing for. So it really is, okay, well, you're saying that the effect is racial discrimination, or is the effect a result based on racial considerations? And that, so that argument, I think, while superficially it seems to make sense, I think when you dig a little bit deeper and scratch on it a little bit, it actually proves the weakness in that argument. Because if you follow what they want in the end result, the only way they can get there, and this would be Alabama's argument, is that you use race as a controlling factor. I know that probably didn't make a lot of sense, but I think that if the liberal justices' arguments taken to its logical conclusion, that's what you end up with.
There's also a flip side of that argument that the liberals criticize the conservatives or criticize Alabama and say that you are seeking to undermine the purpose of the 1982 amendments. But the argument in reverse, it seems to me, is that if the liberal interpretation carries the day, if the challengers to this districting scheme win this case, then basically the interpretation of Section 2 that carries the day is, if we can draw a district to bring about proportionality based on racial demographics, then we have to. And the court has not, to this point, been willing to say quite that much, but
in fact, I think
what we mean by sufficiently large and geographically compact is, well, we can use computers and draw districts that literally span the entire width of the state to loop in whatever Black communities we can find. Then that interpretation does go fairly far, does it not, into creating a right to proportional representation?
Yeah, it does. And one of the things that jumped out at me, nobody actually said it, but when they were talking about the inputs, I mean, Justice Thomas opened up with the question, what's your comparator? But when they started talking about the computer simulations, there was some discussion about the inputs, but the old adage about garbage in, garbage out, if you're using a computer simulation for anything, you can control the results based on the inputs. And if you interject, as one of the experts in the case, I think it was for the Castor parties, used race as a key factor, then you can get into all of this proportional representation results. And whether that's, if that's sort of where the liberal justices are going, it's inconsistent with the case law that's developed since the 1982 Voting Rights Act was enacted, or the amendments were enacted, and certainly inconsistent with the post-Jingles development of the law, even with its confusion.
Now, one of the questions in the question and answer box is directing us toward this kind of thing. But if we get into the predicting votes, I suppose we should talk about that a bit, even if we give the usual caveats that as you show me somebody who's willing to predict what the Supreme Court's going to decide, and I'll show you a guy who's going to lose a lot of money buying the Brooklyn Bridge. But it certainly seemed, and if we look at past cases, it seems like from this argument that Justice Alito was pretty willing to support Alabama's claims. Whereas the three liberals seem a solid vote on that side. Thomas largely silent, but his prior writings make fairly clear what he's going to do. Roberts, to some extent, well, Gorsuch is also silent, so he's a bit of a wild card. Roberts didn't say all that much. Kavanaugh spoke, but was equivocal. So any expectation about what we're going to see from those three who are going to decide which way the court comes out on this: Gorsuch, Roberts, and Kavanaugh?
Well, I think one of the interesting parts of the oral argument was Justice Barrett, because she really sought to understand sort of Alabama's argument, and she pressed Alabama on that. So, I mean, it's a really interesting mix, because I think, with, Justice Thomas's prior writings, and you've got Justice Alito, and I'm going to take Justice Gorsuch is a bit of a wild card, I think. But I think those three you could set off to one side. You could set the three liberal justices off to the other side. I got the sense that, if Justice Roberts writes the opinion, he'll have Kavanaugh and Barrett there, and it'll be a less sweeping opinion than maybe Alito and Thomas would want. But that's kind of how I see it lining up. I tend to give Alabama the upper hand here. But, again, like you said, it's, you're going to lose a lot of money betting the house on how the court's going to come out on this.
And a final point on the predictions, or what we can gather from what we know already. In general, of course, when the court stays a lower court order, you would expect that to be a pretty good indication that the court thinks that reversal is likely. And so, just based on the court's decision over the summer to stay the district court order, or it wasn't the summer, I think it was February, the decision to stay the lower court's order, you might say, well, the smart money is going to be on Alabama here. But a couple of justices wrote explicitly to say that presumption isn't as strong in election cases, because we really are nervous about district court orders that alter election rules in the time before an election. And although February seems like an awful long time before an election in November, it wasn't a lot of time. It was about 2 months before the primary election was scheduled. And of course, candidates need to campaign, and voters need to know who they're voting for. You need to establish districts before those primaries occur.
And so even elections and registrars need to be able to do their jobs too.
That's right. And so so Kavanaugh in particular, an opinion that was interestingly joined by Alito, says, I'm not taking a stand. This is not a decision on the merits, and I'm voting to stay this lower court order mostly on the basis of the Purcell principle, right. This idea that we're not going to allow courts, we're not going to allow federal courts to alter state election rules in the time right before an election. So I think that predicting the outcome, given this stay, is a little more difficult than it might be in most cases that have a similar procedural context.
Do you think, based on Justice Roberts, the way he split the baby, so to speak, do you think, that gives any indication that he may take the lead on this if he's in the majority?
Yes, I would be inclined to think that would be likely, but the Supreme Court is going to take up the affirmative action case. Mm-hmm. And I don't know whether he's going to want to take both of those blockbuster cases decided within a month of each other, or whether one would be passed off to someone else. I think I would be shocked if Alito got an assignment in another high profile case right away after having written the Dobbs decision. And if I were Roberts and had to choose between the affirmative action case and this one, I'm not sure which one I'd take. He seems to have demonstrated an interest in both of those areas of the law. And the property rights case that was argued yesterday is also a high profile case, and Roberts has written on that subject as well. So but directly to your point, I think that point is well taken, that he does seem to like to craft middle of the road kinds of opinions, particularly if he can get 5 votes on on that side. And if he does find himself in the middle and able to craft an opinion, it would make sense for him to take it.
Because he seemed to suggest that, he agrees that there's room for clarification, and that wouldn't, depending on how he wrote the opinion, it wouldn't necessarily be a big sea change. It could just be, sort of clearing up some things on the edges to refine the analysis and framework for future cases, but it doesn't necessarily have to be the big blockbuster decision.
Well, and that would be the real interesting thing for going forward is whether it would be just cleaning up around the edges, or whether that would just be what it would be sold as, that Roberts would write it as an opinion that's just cleaning up the edges, but that would really make a more substantial underlying change. Now, the dissent, I think, is fairly clear that they're going to go to the mat on this one and characterize any decision in Alabama's favor as being quite a substantial change from the way that things were, and from what they view as the proper interpretation of Section 2. So I don't think he's going to be able to craft a decision that's going to bring along the court in any kind of unified way, but he might be able to get one that by not reaching out to make an overtly large claim about changing the law, might be able to accomplish something along those lines and get an interpretation of Section 2 that does place more of a cap on the extent to which race can be used to create these majority-minority districts under Section 2.
And how do you think the dissent would be sort of the full-throated argument that Justice Jackson, raised with regard to the 14th and 15th Amendment, framing it that way? Because I think that would be that seems to me is a pretty big shift in sort of the thinking in that regard.
I'm going fairly far out on a limb on this one, which will either look really good or really bad in another 9 months. But I view Justice Jackson's argument to that effect to be a kind of warm up for next month. That I think that her discussion of the real meaning of the 14th Amendment, or that it's perfectly fine to be race conscious in imposing remedies to make up for past instances of discrimination, I think that's a warm up for the affirmative action cases that are going to be decided at the next court sitting. This one, I think, is going to be full throated, but I think the principal dissent probably would be less focused on that and more on the here's another blow to the Voting Rights Act. That I think Kagan, in her questioning today, laid out the approach that a dissent is likely to take, or at least rhetorically going to take, that you gutted the Voting Rights Act in Section 5 in Shelby County, you did the same thing in Brnovich last year, now you're doing it again here, and all of these election-related cases, particularly involving efforts to protect minority voting rights, are being hacked to death by this conservative court. I think that's going to be the rhetoric that starts with now if it's a dissent, like you said, it could well be the majority opinion, but it's what the liberal wing of the court is going to push, and I think that that's going to be consistent, certainly with the political attacks on the court that we have seen recently.
And that was the thrust of Justice Kagan's questioning, as distinct from where Justice Jackson went and where Justice Sotomayor was going. So yeah, that's point well taken. Was there anything else that struck you? I mean, what struck me was Justice Jackson's argument about the meanings and history of the 14th and 15th Amendment. Maybe struck me so hard that maybe I missed something else. But was there anything else that stood out for you?
Well, it's sort of by its absence. That one of when I consider the Constitution and the constitutionality of Section 2. It's ever since the results test was put into Section 2, it's been an uneasy fit with the 15th Amendment. That is, we're going to write the constitutional standard still is, yet you're not violating the Constitution unless you intentionally discriminate against a racial group. And Congress decides that we are going to enforce that prohibition by not only making it illegal intentionally to discriminate against a minority group, but to impose any kind of electoral practice that has the effect of giving this racial minority group a reduced ability to impact the political process. And so that the scope of Section 5 of the 14th Amendment, or the scope of Section 2 of the 15th Amendment, was I don't even know if it was mentioned at all. It certainly was not a major focus of this case, and I didn't expect it to be the focus, because it would be a step quite far, if not a step too far. But I expected it to get a little more attention than it did. That the interpretation of Section 2 brought about after the amendment to add the results test brings it in potential conflict with City of Bernie versus Flores and those other cases that place a limit on Congress's ability to expand constitutional rights under the guise of enforcing constitutional rights.
And how does knowing that the affirmative action cases is coming up next month, is there anything we can glean from what, other than, the Justice Jackson's sort of argument, is there anything we can glean from today's argument that is probably going to show up again?
Well, that's a fascinating question too. When I saw that both of these cases had been granted cert and that they were going to be heard in the same term, I had thought, boy, there is a possibility that the court could take a really clear stand and say that the Constitution outlaws consideration of race in both contexts. Could just say that districting needs to be done without consideration of race, or even if that's not realistic, at least to say something fairly clear to limit the amount of consideration of race that would be constitutional, and then say something comparable in the affirmative action cases to say that it would be unconstitutional to consider race more or less at all in admissions at state universities and for state hiring decisions and that kind of thing. Given that that wasn't where the discussion today was, I'm not sure that we're likely to get as much of a full-throated, clear, no consideration of race rule out of the affirmative action cases. And if the court, it may or may not play out that kind of way. You could certainly draw a distinction between the two and say, as the court has until this point, that people who draw district lines, of course, they're aware of race. If you say that they can't consider race, you're just being Pollyannish. You're being a fool. Of course, they're going to consider race. The only question is how much they're going to consider race. Whereas in the more typical affirmative action contexts of school admissions and hiring decisions, it is plausible to create a rule that says you have to make those decisions on a race-blind kind of approach. So maybe the court would go that kind of direction, but I think the chances that the court would completely outlaw consideration of race, I think that's to the extent it ever was a real consideration or a possibility. I think it's less of one now.
What did you make of, I think it was Justice Sotomayor's, I guess, lack of credence that she gave to Alabama's argument about the sort of the geography when they were talking about the Black Belt, that, seemed to make, it seems to make sense. You've got a river, you've got a couple of bodies of water that separate areas when you're talking about communities of interest and geographic compactness. Physical boundaries have always been something that have been considered in the analysis, but she really didn't give that much credence.
Yeah, I agree with that. Now that does, I suppose, have the advantage of clarity that we know where Justice Sotomayor stands on those kinds of issues, that for her, race must predominate. The Voting Rights Act requires that you draw districts to protect these racial interests whenever it's possible to draw a district that includes a majority of members of the minority group, whether you cross a river or a mountain range or whatever, doesn't really care. And now that's also nothing all that new. Even in Reynolds versus Sims back in the mid 60s, the court has this funny line about how now that we're in modern times and we have these communications technologies that allow us to cross rivers, and that we don't have to worry about those natural boundaries as much anymore. But I think it's fairly clear that Sotomayor would look at that as an excuse, that Alabama is glomming on to a river or a mountain as a neutral sounding reason for not providing blacks with adequate voting rights. And she more or less said that explicitly in her discussion of Alabama's justification of communities of interest, when Alabama said that we don't want to break up the community around the Gulf Coast region. We don't want to break up the current District 1 and District 2 in order to split them and form this new wide band of a new District 2. Sotomayor basically said, you can say it stems from French and Spanish ancestry over hundreds of years, but she pretty much scoffed at that explanation, or said that it was a way of doing racial discrimination without coming out and saying it.
And they also, I think it was Justice Sotomayor and Justice Kagan, when Alabama, the Solicitor General, pointed out, that look, their map had some relation to the pre-existing districts, and that is one of the traditional districting principles that's considered. They glossed right over that, seemed to ignore that. I think that's kind of the same, as you mentioned, how they ignored the geographic issues. They treated it sort of the same way, which leads the inescapable conclusion that the argument from their perspective is really race, has to be a controlling factor in the analysis that they would put forth.
I was curious why you thought Gorsuch was so silent during the arguments today.
I don't know. I suspect that he knew what his answer was going to be and didn't think that it was going to be all that, for the same reason that Justice Thomas has said that he's silent. I'm not going to take up other people's time trying to convince the other members of the court when I know what I already think about the case. But I don't know whether that's true. Gorsuch was quite an active questioner in the case on the meaning of Title VII, a sex discrimination cases including sexual orientation and transgender discrimination. And so his a noteworthy case where he interpreted a statute passed in the same era as the Voting Rights Act was passed, so I was kind of surprised that he didn't follow suit there and was an active questioner. I don't know that it says anything, but I kind of suspect that it means that we probably don't have a big surprise coming from him. I think that that if he were thinking something unexpected, that I would have expected to hear more from him in oral argument. But that's just my seat of the pants kind of thought. I don't know that it has any reflection of what he's actually thinking.
David?
I don't either. I mean, sometimes they're Sphinx-like, and the silence. You can read it either way. So I don't know. I was surprised that he didn't ask any question. I don't think he asked a single question, did he?
I didn't hear him at all.
Yeah.
And with this being Justice Jackson's second day on the court, what do you predict for her tenure on the court so far, based on the 2 brief days she's been active?
Well, I as I mentioned before, I was struck by her forceful argument for the interpretation that she put forward for the 14th and 15th Amendment, and how that should apply in this case. And that if that holds true, I think she's going to be quite active in arguing from the more liberal side of the court for a completely different reading than what has been coming out of the conservative wing of the court. I mean, I think she's going to be very active and very vocal justice. I mean, in the second day, yesterday she was very active in questioning, and today she was, I think Justice Thomas asked one question and then she took over. So she's very active.
I think it'll be interesting to see how the rest of the court reacts to that. If she does continue with that technique, whether the conservative wing on the court will feel compelled to speak up too, and or whether some effort will be made to say that like during the pandemic, that everybody gets 2 minutes or the 5 minutes or however much it was, and we're just going to rotate through the bench. Justice Scalia, when he joined the court in '86, got some of the same kind of write-ups about him, that he was coming from the DC circuit, like Justice Jackson was coming from the DC circuit, had a very active approach to oral argument that fit his personality. And some of the members of the court didn't appreciate it. I think it was Justice Blackmun who made some kind of remark about how, back in my day, we all, we sat and respected the people who had been here for a few years before we became as active as Justice Scalia was. And I always thought that was kind of a bit fusty. There wasn't much of a need for that kind of deference. So in that respect, I'm pleased that Justice Jackson is jumping right in to be an active questioner. It certainly is helpful to court observers, and I imagine to advocates, to know where she's coming from. And we don't have to guess about her position like we have to guess about Gorsuch, because their approaches were so different. But I think it will be really fascinating to see whether she maintains that kind of attitude in the future, or how her behavior on the bench changes as this term goes on and her tenure on the court goes on.
And if I recall correctly, Justice Sotomayor was pretty active very early on in her tenure as well. So
I think it's a generational kind of shift that the Justice Blackmun joins the court in 1969 or 70. I just think it's a completely different era from the 80s, and certainly from now, that justices, they might decide, like Justice Thomas, not to say much during oral argument at all. But I don't think that many new appointees are going to exhibit a kind of, I better not speak up and I better defer to the people who've been on the court for 10 years when I'm just starting out. I just don't think that that's an attitude that's likely to be reflected by more of the appointees in this current generation.
And despite his silence today, I know there was some criticism of Justice Gorsuch early in his tenure for his active participation.
Yeah,
I think you're right on that.
Yeah. And I just want to thank David and the Federalist Society for the opportunity to take part in this. It's been an honor and a pleasure. Thank you.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.